Okay, so this video is part one of acts, regulations, rules, etc. What's the difference and why does it matter? The answer to that is only by understanding these issues can you understand how you're being brainwashed in investigation reports. And so this is a critical video, and it's one that everybody needs to go through before really going through my other materials, because again, my videos build on one another, and these are just such critical issues that you're not going to have the proper understanding of what's coming up in the future if you don't go through these materials first. So again, before we get into this video, I would like you to like, share, subscribe, and make sure that you're still subscribed if you have subscribed in the past, because the likelihood of people getting unsubscribed, in my opinion, is very high, because there are just so many parties that don't want this information to get out to the many rail families that need to understand these issues. Okay, I've taken this screen print from a Government of Canada website, as you can see in the URL above here. And this website provided a guide to making federal acts and regulations. So this is directly from the Government of Canada. And it states that there's many different types of rules, or basically legislation. And so the important point here is note where the arrows show acts, regulations, or directives tend to apply to groups of people and have legal force, in that they can be enforced by the courts. So if something falls under an act or a regulation, that is enforceable in court. Unlike guidelines, voluntary codes, or standards, or self-imposed rules, for example, the Canadian Rail Operating Rules, or anything else that is defined as a rule, they do not have legal force. And so they rely basically on persuasive or moral value, but they can't be enforced in courts necessarily. And so the issue becomes, as we water down acts and regulations and we make regulations become rules, we're going from something that can be enforced in a court versus something that cannot. And so that is the most critical point you need to understand as far as all these materials. And acts override regulations, regulations override rules, guidance, standards, etc. But only acts and regulations are clearly enforceable in court per the Government of Canada's own website. Okay, so again, from this same guide to making federal acts and regulations, and acts and regulations, I mean, they're pretty well the same, not, word for word. I don't mean word for word, but I mean as far as the processes and as far as their the ability to enforce them. That would be pretty well the same in Canada and the US. An act is an act, a regulation is a regulation. And so if we look a little more at this guide to making federal acts and regulations, put out by the Government of Canada, regulations, again, have legal binding effect, but regulations are not made by Parliament. Rather, they are made by persons or bodies to whom the Parliament has delegated the authority to make them, such as the Governor and Council, a minister, or an administrative agency. So in the US, the same type of thing would likely apply, where a regulation can be made under the Enabling Act, and that regulation could be made by the Secretary of Transportation, for example. So the part here on an administrative agency being able to make regulations. Well, what's an administrative agency? It would be something like the Canadian Transportation Agency in Canada, or it could be the Railway Association of Canada, if that agency is given the power to make regulations by the Minister of Transportation. And really, the bodies like the Railway Administration, not the Railway Administration, but the Railway Association of Canada, and let's say the Canadian Transportation Agency, there could be rail executives. Well, the Railway Association of Canada and the American Association of Railroads, those two are absolutely made up of people who are in the rail industry, rail executives, etc. I mean, there is no doubt about that. So again, you've got the fox in charge of the hen house here. They're making laws that are enforceable in court. And so if they're breaking those laws, um, there's a lot of issues there. And if they're breaking those laws, are they really going to be doing proper compliance audits and whatever to make sure regulations are being observed in matters pertaining to the training of the rail workforce, for example? So there's a lot of issues there when you have rail executives making the laws. And there's also, when it comes to the Canadian Transportation Agency, there's different people that can be on that one. Rail executives, absolutely, like Jeffrey Hare, who came from CP Rail, and he was there when he was overseeing the Canadian Transportation Agency when they had the Mackyard incident in 2007. And I believe he was there until 2015, so he was definitely there overseeing the railway employee qualification standards regulation, which falls under the enforcement of the CTA. When conductor trainee Jason Clooney was killed, Jeffrey Hare, who was a CP rail executive and who would go back to CP after his stint at the CTA, he was the guy overseeing the Canadian Transportation Agency and overseeing those regulations tied to training programs for rail workers. He was also obviously the person who was there when then Minister John Baird issued a Railway Safety Act Section 19 order, which was supposed to overhaul all training programs for frontline rail workers. And that, again, was a complete and total public scam, in my opinion. We're going to get into all of that. But again, important to understand here, regulations can absolutely and are made by people who have massive conflicts of interest because they can be rail executives. Okay, now when something becomes a law, and I'm sure this would be the same type of procedure in the States, there is a formal publication for the Government of Canada, and I'm sure there's one in the US, where new laws are published for the public to know that this is now an active law and the law of the land. So if you look here, this is a copy of a page that I received from via a Freedom of Information request or access to information request. And it's a page from, if you look at the top arrow here, the Canada Gazette. The Canada Gazette is the official publication for the Government of Canada that will tell you when something became the law. And if you look at the bottom arrows here, you will see the copy they gave me is a little bit blurry, but you will see that where the arrow is on the left here, that the Railway Employee Qualification Standards Regulation, the date that they provide for that becoming a law was March of 1987. And you can see here the first arrow on the right, the bottom right, that one shows the document name SOR 87-150. And then the date is the next arrow for March of 87. And so, by the way, it remains the law to this day. And so that is in spite of what I call that public scam known as the Railway Safety Act Section 19 order, which was provided in the Transportation Safety Board Railway Investigation Report R07T0270, which is the report tied to the Mackyard incident outside of Toronto in 2007, which resulted in the supposed overhauling of all training programs in the rail industry. And that is something that the overhauling of those programs, because the order was given to all rail carriers, it would be the Railway Association of Canada, which was basically the administrative agency here, that would come up with the new rules respecting minimum qualification standards for railway employees. That was the name of the new document, Rules Respecting Minimum Qualification Standards for Railway Employees. It was also known as TCO 0-102. Now, note here, that new document was a rule, not a regulation. So they were going from what was a regulation and attempting to make it into a rule. Regulations are enforceable in court, whereas rules are not. And that's, again, the key point here. Okay, so this particular page comes from Railway Investigation Report R07T0270. And again, that's the critical one throughout all this information here that we're going to be going into. But that's the one that has to do with the Mackyard incident outside Toronto in 2007. And this is from page 25 of that report, where under the Railway Safety Act, the Minister of Transportation issued what is known as a Section 19 order. So based on Section 19 of the Railway Safety Act, the Minister of Transportation can issue orders that need to be observed by rail companies, etc. So he issued an order to basically all federally regulated railway companies. And so given those are represented by the Railway Association of Canada, it is the Railway Association of Canada that would come up and with the new rules and collate them for the rail industry for all their members. And they have 50 to 60 rail members in the Railway Association of Canada. And those members include all U.S. Class 1 rail carriers, by the way. So if there's some fishy stuff going on, I think lawyers could probably argue that all those members could be liable, including those U.S. Class 1 rail carriers. So again, the order went out to all federally regulated rail companies that operate in Canada, and they were told to develop and file a rule, not a regulation, a rule to update and replace CTC, which was the Canadian Transportation Commission 1987-3 rail, which that is another name, by the way, for SOR 87-150, which is the Railway Employee Qualification Standards Regulation, or the key document for railway employee training programs. So look at what we're seeing here. We have a Minister of Transportation basically watering down the laws that are there to protect frontline rail workers and the public in general and rail investors, because you're watering down laws and trying to go from regulations to rules. And again, regulations, which is what we have in place, are enforceable in court, whereas rules are not. So why would a Minister of Transportation be ordering all operating rail carriers in Canada to come up with not a regulation, but a rule to replace a regulation? Folks, in my opinion, that should be considered criminal negligence on the part of the Minister of Transportation. And that's why I call the Ministry of Transportation, Transport Canada, a rail partner in crime with rail carriers when it comes to so many of these issues. Because clearly, if a Minister of Transportation, after a railway incident in Toronto, which really made it come to light that there were massive problems with the proper training of frontline rail workers, and your safety action taken in a railway investigation report is to try and water down the laws. They take these things, never let a good crisis go to waste. So when you have a railway accident or incident, the industry and its regulators are clearly taking that as an opportunity to water down laws. And that is exactly what we're seeing here in writing when a Minister of Transportation is ordering the replacement of a regulation with a rule. Very, very serious issue. And if you look at the bottom paragraph here, it says that in June 2009, the revised rules were approved. These rules will come into effect once all federally regulated railway companies become signatories to the new rules. And the key point here, the current regulations are repealed. So in order for a law to go into effect or a rule, if there's something that it's replacing, in this case it would have replaced the SOR 87-150, the Railway Employee Qualification Standards Regulation. So if the new rules were to replace that, then because regulation is enforceable in court, and because it's a regulation, it has to be repealed by the government. And so that, folks, never happened. I don't know if that was due to a timing issue because of government changes or changes in who was the Minister of Transportation at the time. I don't know why it never was repealed, if somebody saw, wait, this is a problem, and blocked it. But the fact that this was even approved, this new scam document called Rules Respecting Minimum Qualification Standards, it was known also as TCO 0-102. The fact that that scam document never went into effect is good. But again, what you need to note here is that that document, that same document, those new rules, which never went into effect, was referred to in the death investigation report in 2013. That report came out in 2014. But pertaining to the death of conductor trainee Jason Clooney. So you have to ask yourself, why is the Transportation Safety Board using a document and referring to this public scam of a document? In my opinion, the fact that any taxpayer money would have been wasted on this scam document, and Railway Safety Act Section 19 order that was issued, when we go through that, you're going to see what a scam that was. But you will also see why a death investigation report pertaining to the death of conductor trainee Jason Clooney, it's like they created this new document called Rules, and then they get to pull key sentences out of it to then put into a future investigation report, such as that into the death of conductor trainee Jason Clooney, to be used as part of the brainwashing. And you're going to see exactly how that works when we go through that. So again, Transport Canada's Minister of Transportation tried to replace a regulation with a rule via this order, and the new rules were approved in June of 2009, but the old regulation was never repealed. Whether or not that was just a mistake, in an administrative mistake or whatever, we're going to be looking at that. But the fact is, SOR 87-150, the Railway Employee Qualification Standards Regulation, is still very much the law of the land. It is still a regulation, and as such, still very much enforceable in court. Okay, so another page from this same report tied to the Mackyard incident outside of Toronto talks about what CN was going to be doing to review all of its training programs. And you're basically seeing them saying here that they're going to be taking the best practices in effect at all. They're going to be reviewing all terminal processes and whatever, and then they're going to take the best practices to help overhaul their training programs. But I just want to show you here where I'm getting the information that is tied to training programs as they existed at the time for the Mackyard incident, because based on that and what was provided in this report going back to 2007, you can see that even in 2007, Transport Canada knew there were serious problems with the training of frontline rail workers. And so that issue was identified almost 20 years ago. And at the time of the death of conductor trainee Jason Clooney, and I would say even further out than that, much further out, almost, I would argue in some instances even to this day, those training programs still have a lot to be desired. They are still, in my opinion, totally deficient. And when I requested a copy of the new training programs, any changes to training programs, etc., from the government of Canada, they basically came back with nothing. And the health and safety officer who investigated the death of conductor trainee Jason Clooney in 2013, he died at the end of 2013, so most of that investigation would have been in 2014. And even he said that the materials that he received from the government seemed rather outdated. So, huge issue. I don't think these issues were ever addressed. That's my personal opinion based on what I know and what I've read and what I've seen and, what my child has told me about a lot of the stuff going on in the Canadian rail industry. And so, again, still a huge issue almost 20 years later. Why is that? Okay, so again, from this same report, the following page, page 27, Appendix A, it shows here Macmillan Yard Fast Track Conductor Training Course content. So this was what CN Rail provided as its current training program when that Mac Yard incident happened in 2007. And it's important for people to understand this was at CN Rail. CN Rail and CP Rail were both crown corporations of the government of Canada. And so they were part of the government of Canada basically until 1995. And in 1995, when they were part of the government of Canada, the training programs for frontline rail workers were 2 years long. So when in 1995, both these companies became privately traded companies and were no longer under the arm of the government of Canada, but instead now they had stockholders, they made a change from a 2-year training program to one that was about 6 months, 4 to 6 months in length. And so what's provided on this page, page 27, is that shortened fast track conductor training course. So they had 2 weeks of classroom rules instruction, followed by 2 weeks on trial trips for where the conductor trainees would be on trips just for observation purposes. Then they have 2 weeks classroom training and rules, and there it's called the Qualification Standards for Operating Crews, or QSOC. That is a really old name for qualification standards regulations. Then they had supposedly 2 weeks of belt pack training. But again, what's interesting is that in 30 years, did not seem to have a belt pack training program really on file with Transport Canada. And we're going to get into belt pack issues separately. That's a whole other one. And then they would have 45 trial trips with qualified conductors. So I just want you to see when I'm talking about training programs, where I got my starting point is based on this Transportation Safety Board report R07T0270, which resulted because of the Mac Yard incident outside of Toronto, and which showed that things were really bad as far as employee training programs. And so this is what CN Rail had provided as its current training program for this Transportation Safety Board report. Okay, so this is page 28 of that same report for the Mac Yard incident. And what I want you to see here, where I added the red arrows in the old training programs, this just shows to me the stupidity of the whole regulatory environment, because it used to be that if you look at the last 2 arrows here, at the end of the first year of service, they would be re-examined and required to pass in order to continue. So, however, under the previous structure, there was a high failure rate on the retests. So when they retested conductors after 1 year, too many of them were failing. And so our answer was to go, per the first arrow, to a 3-year retest. Explain to me the logic in that. If they're failing after 1 year, shouldn't you be, retraining, whatever, making sure they can pass and still keep going rather than waiting for 3 years to do a retest? Shouldn't you be making sure that in years 1 and 2 and up to 3 that they are properly trained? If there's so many of them failing after 1 year, why is it safe for them to go on and now only be retested after 3 years? I mean, the logic of that is absolutely insane. It clearly was a cost-cutting measure, because if that many of them are failing, that would incur a lot of extra costs for these rail carriers in order to keep retesting employees that were failing. And really, the bottom line is, folks, they obviously were not being properly trained and qualified from the start. And we're going to get into a whole lot more on that. And that's what the Mackyard incident was really showing, and what the death of conductor trainee Jason Clooney years later would continue to absolutely show, and that things were actually getting exponentially worse. So I don't care if you're retraining every 3 years or retesting every 3 years. Based on this, where's the logic? I mean, if they're failing after 1 year, why are you waiting 3 years now to retest? Why aren't you retesting after 6 months and then, remedying whatever training shortfalls there are? It would seem that your retesting should be earlier rather than years later if there's a problem with training and with retesting. Just my opinion, but hey, what do I know? Okay, so again, on this same railway investigation report, this is the next page, page 29, and this just gives you a sample conductor trainee evaluation form. Basically, the procedure is that every time there's a conductor trainee goes on a trip, whether or not he's working in a yard, he or she is working in a yard or on the rail lines between terminals, whatever, the supervising conductor is supposed to complete an evaluation form. And there's like 65 different skills that a conductor trainee is supposed to be proficient in order to be a qualified conductor. And so it's everything from, general stuff, belt pack, you've got riding equipment, you've got everything here. Like you've got, let's see, coupling and decoupling, you've got switches, you've got point protection and point protection zones. So it's all different aspects of the rail industry that they need to be qualified in, that they need to show competence in before they become qualified conductors. Now, here's the big issue. A lot of the places where conductor trainees work are not considered rail yards, and they're supposed to have yard training. In the case of my child, and if it was true for my child, my child ended up being qualified with 0 yard training, and then was allowed to go from a yard of 2 to 3 switches a day, 2 to 3 trains a day, to a yard with 40 to 60 trains a day and potentially hundreds of switches with 0 yard training. So the definition of a yard and how it changes over time, and how, these administrative agencies who write up the new rules have changed definitions over time, is a huge issue when it comes to things like the definition of a yard or a transfer. We're going to get into all those issues because, folks, just as the old regulation for SOR 87-150 was never repealed, the old definitions for a yard and a transfer seem to have never been repealed either. And so that's a huge issue when it comes to the proper training of rail employees. And there's only about a dozen actual rail yards which would allow for the full training required for a conductor trainee in Canada. So you've got the big ones like, Edmonton and Winnipeg. Those like, Mac Yard. Those are the ones that would provide the opportunity for things like the point protection zone training or for the belt pack training. A lot of yards don't have that. And so how is it that people are being qualified as if they've passed all of this training? And then, if you're in a small terminal like my child was, and then you're just after a couple of years, after a year, let's say, oh, you're now considered a qualified conductor, and so you apply to move to a bigger yard. And the people in that bigger yard, as was the case in my child's training, when my child moved to the bigger yard, the people that are there assume that proper training has happened and that you are qualified in point protection zones and the proper signal. There's something called OCS territory, which is an occupancy controlled territories where there's no signals there. You have to call the rail traffic control and get permission to advance to the next section of tracks, basically. So if there are no signals in certain areas, how are people being trained on signals? You're not. And so you could be a qualified, supposed qualified conductor, and then with the passage of time, well, you're qualified, you have a lot of experience now, so we'll allow you to transfer to another terminal thinking that you're properly qualified when you're not, because you had huge gaps in your training, as was the case with my child, who was allowed again to go from a yard of 2 or 3 switches a day, or two or three switches and 2 or 3 trains per day, to a yard with 40 to 60 trains and potentially hundreds of switches. And that move was allowed by CN Rail, knowing that my child basically had 0 yard training. And in the case of conductor trainee Jason Clooney, again, I was told by someone who had become quite close to my family, and he was a conductor trainee at the same time as Jason Clooney, and he had told me that the word in the field was that Jason was being qualified the day that he was killed. Now, if that's true, again, that's a huge issue, because when I requested a ton of information pertaining to the death of conductor trainee Jason Clooney, one of the slips of paper I received showed that Jason Clooney had 0 yard training. And so again, the whole issue, when a conductor trainee gets killed, I have to tell you folks, those are the ones that really show the problems with the entire process when it comes to the proper training of rail workers. And that's why the case of conductor trainee Jason Clooney is so classic and so important in what it shows and reveals, not only in 2013 when he was killed, but clearly that the problems were known of in 2007 per the Mac Yard incident, and that those problems, many of them, continued to exist long after the death of conductor trainee Jason Clooney, as was the case in another death that I started investigating. And that was one where the investigation was happening in the 2018 timeframe. So folks, and now, because Transport Canada knows that, the gig's up and families are becoming aware of what the issues are, what used to take maybe 10 months for a railway investigation report, boy, some of them now can take 2-3 years for those reports to come out, because when you've got that many lies and misinformation in railway investigation reports, as is clearly the case in the death of conductor trainee Jason Clooney, it takes a lot more time to put your story du jour together and to try and put all of these, these lies together. There's no other way for me to put it. We're being lied to and we're being brainwashed. And there's really no other way to put it, folks, when you see all the information that I'm going to be giving to you. So that's the big issue. And the other issue with these evaluation forms is, even though technically according to the training programs and whatever. These forms are supposed to be filled out every time a conductor trainee goes out on a trip. Well, in the case of Jason Clooney, almost 25% of his evaluations were missing. And that I don't think is just an issue for him, just my opinion, but again, another huge issue. If you've got training evaluations that are missing, how can you possibly do a qualification of a conductor trainee if 25% of the information is missing when they're supposed to be tested on all these different skills? So you not only are missing the opportunity for certain skills to be developed, like point protection zones or proper, reading of signals and whatever, if that opportunity doesn't even exist in the supposed yard where the trainee was working, and that only exists in maybe a dozen actual yards. But a lot of conductor trainees, folks, are not trained in those yards. They get deployed all over the country to work at all what are considered switcher locations. They're not actual yards, but yet we say that they have yard training. Well, again, it all gets back to what is a yard? And so the definition of a yard and how it has changed over time becomes a critical issue. And I think I'm going to be able to show to you that the old definitions of a yard, dating back, decades, has never properly been repealed, in my humble opinion. So just more issues for you to be aware of. Okay, so again, from the railway investigation report from the Mackyard incident in 2007, a little earlier in that report, there was this table on page 11, which provided also a summary of the conductor trainee training program. And so when I'm referring to the training programs for conductors and other materials and stuff, this is where I got my starting point, was in this investigation report and what was provided there by the Transportation Safety Board, according to information they would have most likely received from either the rail carrier itself, in this case it would have been CN, or from Transport Canada, where training programs are supposed to be filed with the Minister of Transportation. So if you look at this, what was provided there, and remember, before 1995, the training program for conductors, when CN and CP were Crown corporations and part of the Government of Canada, the training programs were 2 years long. Here, they are 16 weeks long, according to this table. 16 weeks is 4 months, folks. So we go from 2 years to 4 months, and then we wonder why trainees are failing after 1 year when they get retested. You can't cut that much experience out from a trainee and then expect them to know how to do everything and be proficient in everything, especially when they're not working in actual rail yards, but rather that they're working in switcher locations, as would be the case for potentially, thousands of frontline rail workers or conductor trainees. So you get in week 1 and 2 your classroom instructions. Then your observation trips are supposed to be weeks 3 and 4, and there's huge issues with those two. Then weeks 5, 6, and 7, you're supposed to be back in the classroom for more on the qualification standards for operating crews, which was, basically the Canadian rail operating. It's been replaced by other terms like the Canadian rail operating rules and whatever. So here trainees are tested on knowledge and must pass a test in order to continue in the course. There is no test on yard knowledge. What they mean there is that you don't need to know all of the switches or all of the track numbers in the yard. Now, that's very different than knowledge as far as switches and installing derails and knowing how to properly reverse switches or read signals or how to do point protection zones in a yard. So when they say there's no test on yard knowledge, that's not in the actual skills you're tested on, that you're supposed to be proficient in according to that um, evaluation form. That's the actual layout of the yard, that they didn't need to be tested on the layout of the yard where they would be conductor trainees. That in itself, in my opinion, is also an issue, because if you're going to be um, a trainee or a conductor in a yard, you should know the yard properly. You should know where the tracks are, where the switches are. There's a lot of accidents that happen because people don't seem to know their yard. Just my opinion. Then there was weeks 8 and 9 for belt pack training. My child didn't even get belt pack training during uh, the time that they were a conductor trainee, because again, they were in one of these occupancy zones where you didn't do belt pack. Belt pack is like this remote control operations where you literally have this pack on your chest with buttons, and you're like a remote control little truck or kid's toy. You use a remote control to operate locomotives, to push trains and rail cars together to form trains. That can only be done, really, I mean, it's done primarily in a yard. My child never had belt pack training um, when they were a conductor trainee. Actually, my child was a fully qualified conductor and was allowed to move to that much, much bigger yard without any belt pack training, and the belt pack training happened there. And there's a whole lot of issues I'm going to get into with belt pack training. That's going to be a whole separate video. And there's a lot of rail accidents that happen because of belt packs and problems with those. So, it's called remote controlled locomotive operations. So they use the word belt pack because I think that was the actual name of the company or that's what they were referred to, was belt pack, but it's really known in the rail industry as remote control locomotive operations. Then the trial trips were supposed to take place from week 10 to week 14. Now, if you look there, that was supposed to be a minimum of 45 trial trips in yards and road operations under the supervision of an experienced conductor. Key word there, an. An would imply one trainer for the duration of the training program. And if you look here, the qualifications test, which you would pass at the end of the program, was supposed to be administered by the conductor trainer. That's singular, again implying one trainer. Huge issue with that, because you're going to find that a person doesn't have one trainer. You could have a trainer on one shift, and then for the whole 45 different shifts that you have as a conductor trainee, minimum of 45, you could have a different trainer for each and every one of those shifts. And the case of conductor trainee Jason Clooney absolutely showed that there was no communication from one trainer to another. And so with no communication from one to another, you don't know, what the weaknesses are for a conductor trainee from one trip to the next. And so how are you supposed to work on areas of deficiencies or areas that need more work when there's no communication among the trainers for these conductor trainees? Huge, huge issue. So here on the weeks 10 to 14, the student is expected to operate yard assignments. Again, definition of a yard would be key here. And apply theoretical learning to build trains or to perform the duties of a conductor on road assignments. Well, you're not allowed to perform that would be under the supervision of, again, at the top here, under the supervision of an experienced conductor. You're not supposed to, as a conductor trainee, be working alone, unsupervised, as was the case when conductor trainee Jason Clooney was killed. So conductor trainers also are supposed to provide written assessments of progress. And again, in the case of conductor trainee Jason Clooney, 25% of those were missing, and he had 60 trips at the time that he was killed. So 25% of those assignments, those evaluations, were missing for conductor trainee Jason Clooney. So there's a lot of issues when it comes to this, and we're going to get into all of it. But key to the training, again, is the definition of what constitutes a yard and an experienced conductor supervising one person carrying the trainee through the program. Now, I could see why maybe you'd want more than one, but there has to be communication among those trainers in order to properly train a conductor trainee. And when that doesn't happen, you get things like the death of conductor trainee Jason Clooney. So, huge issue. Okay, so this is from that same report from the Mackyard incident, page 30. Appendix 6C here shows what the rail carriers or their agency were supposed to provide as far as revisions to railway employee minimum qualification standards. And again, here in the first paragraph, you can see that the all federally regulated railway companies were to develop and file a rule to update and replace the Railway Employee Qualification Standards Regulation. So again, the minister ordered a watering down of the laws pertaining to railway employee training programs. And these are laws that are there to help protect not just frontline rail workers to ensure they have proper training, but they're there to help protect the public in general, as well as rail customers, rail investors. And so you've got a minister, again, ordering that a rule replace a regulation. And a rule is not enforceable in court, whereas a regulation is. So this is what they were supposed to provide. Definitions similar to those of the Railway Employee Qualification Standards Regulations. And I haven't seen the definition of a yard in those regulations, in the regulations or in the updated, in the new proposed rules. But those definitions definitely did occur in previous documentation that appears to have never been repealed. So that's critical. And then the rule was to apply to all occupational categories and any railway position directly engaged in the movement or control of equipment in yard service or on the main track, and railway employees authorized to operate cranes or other machines, moving equipment. Okay, so the occupational categories would have been locomotive engineer, conductor, remote control operator, yard foreman, hostler, rail traffic controller. Now, remote control operator was not an occupational category in the Railway Employee Qualification Standards Regulation, and that was Appendix 14 of that regulation. So it was never there as a separate operational or occupational category. And so the Mackyard incident outside Toronto involved remote control operations. And so here you've got the minister saying you need to file a program that will include also remote control operator training with Transport Canada. And then it was supposed to also include a description of all training programs for each occupational category established by the railway company, the identification and establishment of certification standards, okay, for each category identified, for classroom training instructors, for on-the-job training instructors, and for contract training inspectors or consultants. And there's huge issues with all of these, and we're going to be getting into that. And it was supposed to also include criteria for testing knowledge, and it shall include but not be limited to training and examinations in the railway's rules, federal regulatory requirements, and practices for the safe operation of trains, covering the following subjects. So it would have been personal safety practices, operating practices, equipment inspection practices, train handling practices, and compliance with federal safety rules and regulations. That whole issue of compliance with federal safety rules and regulations, that's a huge issue. Where are the compliance audits? Because I requested that from Transport Canada um, and Employment and Skills Development Canada. Nothing was given to me on audits into these issues. Um, and then accurately um, measuring the person's knowledge of the covered subjects. So if these are subjects that pertain to actual rail operations where you have to be in the yard or out on the line, doing switching, installing derails, whatever, there's only one way to measure a person's knowledge, and that is to have the supervising conductor right next to the trainee in order to evaluate that knowledge. And again, in the case of conductor trainee Jason Clooney, when he was killed, he was half a mile to two-thirds of a mile from his supposed supervising conductor, working alone in the dark in unfamiliar territory, when some of his evaluations had previously shown that he had problems with working independently and with switching operations. And yet they allowed that guy to walk off in the dark by himself, unsupervised. In my opinion, total criminal negligence. And then they were supposed to have the development and identification of the certification process, which would include testing knowledge, minimum passing marks, the issuance of certificates, the monitoring of performance, and refresher training. Um, Again, huge issues with all of that. And especially when you get into things like managers at the controls, because the regulation for these training programs, the Railway Employee Qualification Standards regulations, which is again the law to this day, does not distinguish between, a conductor trainee who is a regular conductor trainee versus managers at the controls. There is nothing in the regulation for special training programs for managers at the controls. And by managers at the controls, I literally mean accountants, IT programmers. When the rail carriers are having peak periods, like when they have to move the grain or they're short, things are going bad, especially like in the winter where trains are constantly breaking down. In the winter, you may need 3 times the crews you normally need in the summer because there's so many breakdowns. And a lot of times you can't move trains as fast as you need to because of storms, because of more derailments, because of ice on tracks, whatever. You need a lot more crews usually in the winter than you would in the summer months. And so what happens is the rail carriers bring in managers and they put managers at the controls. And I'll go through one of those incidents that happened at CP Rail where you had 3 managers at the controls in the unit. You didn't have, your typical qualified conductors. These were 3 managers at the controls. And I'm going to show you the types of problems that surface when you have companies that have special training programs for managers where you don't even need to pass the, rules tests or whatever to be supposedly qualified to operate a train. There are no special training programs in the Railway Employee Qualification Standards Regulation. There's only an operational or an occupational category. So you're either a qualified conductor or you're not a qualified conductor. There's no room there for pseudo conductors or pretend conductors or managers pretending to be conductors because they were given a special, even more condensed training program, which may have only lasted a week or 2 before they were put at the controls of a train. And that, folks, is an absolutely huge issue. But we're going to get into managers at the controls again as a separate video. I guess I should clarify, I can't remember the exact timeline and length of the managers at the controls training program as was at CP Rail. I don't know how many weeks it was, so I'll definitely get that for when I do that video on managers at the controls. So I said a week or two. I can't remember how long it actually is, but when I do that video, I will definitely be providing that information for you. Okay, so the last page of this report, the R07T0270 Railway Investigation Report into the Mac Yard Incident, on page 31, it continues here with the Section 19 order that was issued by the Minister of Transportation. And on point 7, it gives the criteria for the training programs and the consultation. So the railway companies, when they modified their training programs, had a duty to consult with the unions, for example, representing the employees that would be impacted by any changes to those programs. And within a specified time period, they had to determine, after coming into force of these rules, a railway company was to file with Transport Canada, basically a description of all training programs related to each occupational category. And within a specified training period or time period, they had to determine, after any change was made to the employee training program, the company was to file with again, Transport Canada, a description of any changes. So I think rules probably have a lower standard than a regulation. Regulations and changes to training programs per the Railway Safety Act, Section 19, absolutely have to be approved by the Minister of Transportation before they go into effect. Given rules are not enforceable in court, I don't know if the same would apply to a rule. If there's a change to a rule, does that need to be approved by the Minister of Transportation, as would be the case for a regulation? Maybe not. Maybe with a rule you just need to file your changes. I don't know. But definitely for changes to regulations, and it does say changes to training programs in the Railway Safety Act. It doesn't seem to distinguish between rules and regulations there. It just says a change to training programs. So I think lawyers could argue that all changes to training programs must first be approved by Transport Canada and the Minister of Transportation before they go into effect. But point 8 here has to do with the criteria for monitoring operational performance of occupational categories. So criteria regarding yearly reporting, etc. Now, the important one here, they've got the number of employees in each occupational category who took part in the training, the successes and failures, and follow-up actions taken. Okay, now for successes and failures, okay, so we have new training programs, and we're going to tell you how many passed the training programs, how many did not. Okay, well, here's the issue. Newly qualified conductors could have passed the training program, but then they're on a probation period, and that's required by the union. And that probation period lasts for 6 months or so. And after that, they become completely qualified as far as the union is concerned. Now, here's the thing. There's a lot of turnover in the rail industry, and we're going to get into that and what I think is behind all of the turnover in the rail industry. And it's a follow the money issue, in my opinion. But successes and failures. Okay, so I've got a qualified conductor. He's passed. He's now on probation. What if he gets fired within a year of being a qualified conductor? Does that count as a success or a failure? And the bigger issue is, if that person gets fired for being not fit to be a conductor down the road after they've become a qualified conductor, there's a problem with a person becoming a qualified conductor, then being allowed to train a new conductor trainee. When that person who's still on probation, they're themselves subject to dismissal because they really haven't completed all their training according to the union. And that's a contract that must be observed, the union contracts. So that's another huge issue. And again, it's one that I'm going to discuss as we go further into the railway investigation report pertaining to the death of conductor trainee Jason Clooney. So again, just, what's the regulatory process here? That they have to provide their proposed rules, and they have to be filed with the minister, and there has to be review by Transport Canada before everything goes into effect. And the main thing before new rules can go into effect is if they replace something else, another rule, or worse, a regulation, then the previous regulation must be repealed before those new rules can go into effect. And as I've stated over and over in my materials, the SOR 87-150 Railway Employee Qualification Standards Regulation has never been repealed. And so this whole new safety action taken, what I call the public scam of Railway Investigation Report R07T0270 Section 19 order, in my opinion, that was a complete and total public scam. Those rules never went into effect, but they did provide a good document for the Transportation Safety Board to pull key lines out of in future railway investigation reports. And so that, folks, is how you get to the brainwashing. Okay, so what's key in this railway investigation report that I really want everybody to understand so that you can understand the brainwashing that goes on and how things are done is the fact that the watering down of the laws that were there to protect the frontline rail workers and the general public, with the Minister of Transportation, then at the time John Baird, he was basically there helping rail carriers via this this Railway Safety Act Section 19 order to water down the very laws he, as a minister, was there to enforce to protect frontline rail workers and the general public. And not surprising to me, John Baird would become a member of the board at CP Rail, and he is there to this day. Now it's CPKC, and there's a huge issue with that. You're a minister who's helping to water down laws. You're not there to be watering down the laws as a minister of transportation when those laws are there to protect the public, to protect rail investors, and first and foremost, to protect frontline rail workers. Huge issue, huge problems when you have the fox in charge of the chicken coop, basically, with things like the Railway Association of Canada, where you can have rail executives that are the ones creating regulations. But it's an even bigger problem when the master fox is the Minister of Transportation himself, and he's there helping rail carriers to water down laws. Okay, so I'm going to stop this video here on acts, regulation, rules, guidelines, etc. What's the difference and why does it matter? I'm sure now that you can see it's critical that we all understand the law, especially given ignorance of the law is no defense in court. And so, whether or not you're a union rep, a rail family member, a rail investor, you need to understand these critical differences in order to then understand how you're being brainwashed in railway investigation reports, in occupational health and safety tribunal decisions, which can set very nasty precedents for the rail industry, as was done in the case of conductor trainee Jason Clooney. So all critical issues. So like, share, subscribe. Make sure you remain subscribed. And again, try to view these videos in the proper order that I put them out because they do build on one another. And on that, have a great day.